What if I told you that most credit card agreements wouldn't hold up in court if you challenged properly? Now, in this video, I'm going to break down why these contracts are often one-sided, deceptive, and legally unconscionable. And I'm also going to break down how to challenge them with consumer protection laws. You know what we're about on this channel. I've studied contract law, consumer rights, and the hidden tricks in credit card terms. And I'm here to help you stop blindly agreeing to contracts designed to trap you. Before we dive into this video, this is not legal advice. This is not financial advice. This is literally only put in place for educational purposes only. All right. So make sure you guys stick all the way to the end because we're going to be talking about things that nobody is talking about. All right. Also, if you're brand new, hit the like button, hit the subscribe button. Okay, let's get this video to 300 likes and I'll do a part 2 to this video. You dig what I'm saying? Now, a couple of the key things that we're going to be talking about in this video is what makes a contract unconscionable. And I think that that's going to be a very key factor when we are in the aspect of challenging debt, discharging debt, asserting our consumer rights. And a big part of what goes on in this financial system is that it's a contract system. You dig what I'm saying? When you understand that what we're going through is more contract based and less about, equity in a sense, then you start to maneuver differently. Okay, so we're going to break it down, some of the fine print that be in the contracts. We're going to talk about some of the common abuses of credit card companies and agreements and why they never give you truly informed consent. Okay, and we're going to really break down what's happening behind the scenes. When you get a credit card, you may think that, oh, it's something where they are loaning me money or giving me revolving money. But in order for them to create credit, it requires you. Okay, credit is something that is literally created out of thin air when you sign something and you attach your signature to it. Okay, so I'm going to pull up a couple of these laws, specifically when challenging these contracts. And we're going to bring up some of the foundations of contract law so that you understand what I'm talking about specifically. All right, so let's first dive in to the aspect of what is a unconscionable contract. Okay, a unconscionable contract is considered unconscionable when its terms are so unfair and so one-sided that it shocks the conscience of the court and therefore is unenforceable. So when you think about the aspect of what a credit card is, if you guys don't know, when you apply for a credit card, what happens is that application on that credit card agreement is a promissory note. Okay, that is also a financial asset to the bank that is used to be able to create the credit for your account. But then if we go to the aspect of modern money mechanics, where it says that in modern money mechanics that your money essentially is created not only out of thin air, but it also gets multiplied with fractional banking. So if you ask for a credit card of 10 grand, right, then the bank essentially can multiply that into 100 grand. You dig what I'm saying? And they're supposed to loan that out to other people, but they don't do that. They just ask people to put in more applications and that number just continuously grows. All right. But then we talk about the aspect of when you sign that application, it gives them the fiduciary power to be able to go in and out of the trust attached to your name. So if I told you that every single month when you applied for, or when that one time you applied for that $10,000 in credit, it really gave them the ability to pull that $10,000 out every single month. Okay, to be able to credit that every single month. All right, because technically when you use the money, it's not something that should be loaned, if that makes sense. It wasn't really loaned to you in the first place. It was actually created. So technically, they can pull out that 10 grand as much as they want or create the 10 grand as much as they want every single month. And they do create a new 10 grand or they do acquire this 10 grand from the Federal Reserve Bank. Okay. And I'm not an expert on that. Of course, I will probably do a deeper dive in what's happening behind the scenes when it comes to credit card. Matter of fact, I may put that in my notes. But it's very one-sided, long story short. Because think about it. If you never was loaned money And you just gave them the ability to do that. And then after that, they are having you pay back money that you afforded them to be able to do. That doesn't seem one-sided to you, okay? So obviously, if you knew that that was happening, would you agree to be paying interest on a credit card? You probably wouldn't. So when you think of the unconscionability, it says a contract so unfair that no reasonable person would agree to it. Would you agree to pay back money that was already released to them? Would you agree to pay back money that was already paid for? You probably wouldn't. So it often contains unequal bargaining power. So it doesn't even give you ability to even bargain with them. You got to take them through an administrative process and potentially sue them and shift the burden of proof onto them in order for you to assert your rights. That seems pretty unconscionable to me. But then we talk about the fine print with confusing legalese. We already know that legalese is a legal language that essentially it may look like what we know it to be, but it's actually not. It has a different language in law, okay? Some words can mean something but be completely different in law, okay? And then there's hidden fees and unilateral amendments, so many changes. This would make something very unconscionable when you don't fully understand, when there is no meeting of the minds of what it is that you're agreeing to, that contract becomes null and void. It says a real contract requires full disclosure, voluntary consent, and equal footing, and most credit card contracts violate all three. I want to pull up the contract law foundations. We haven't really gone through this in a while on this channel, but contract law foundations revolve around the core elements that make a legally binding agreement. Okay, so me saying agreement further enforces that your credit card agreements are also considered contracts. So they revolve around the core elements that make a legally binding agreement. These elements include offer, acceptance, consideration, capacity, legality, and mutual assent. Understanding these principles is crucial for anyone involved in drafting, reviewing, or interpreting contracts. So this is why I read every contract, okay? Because I look for the fine print. And it's funny when I go and I get into a contract, and now I typically am very strategic about what contracts I get into. I want you to know, why am I so small? I want to know exactly what I'm getting into, but moreover, I want to see the fraud before it happens so that I can be able to call it out. Because a lot of us are in a situation where, oh man, we want to challenge our contracts, but we don't even remember like how it went. We don't even know if they gave us a notice to cancel. See, when I go and I apply for something and I don't see an option to be able to cancel, I already knew, hey, I'm going to use that against them. Okay, so let's just talk about offer. Offer is a clear, definite proposal made by one party to another outlining the terms of the agreement. This is an offer. And after the offer comes acceptance, means the unconditional agreement to the terms of the offer by the other party, creating a mutual understanding. So in order for one to truly accept an offer, they must have a mutual understanding. But then there's an aspect of you can also reject an offer too, which is the exact opposite of acceptance. Okay, if you reject it, then no contract has been formed, okay? So then we go to the consideration, something of value exchanged between the parties, which could be money, goods, services, or a promise. That this element ensures that both parties are bound by the agreement. So it's very interesting because something of value exchange, money, goods, services, or a promise. So when you promise to offer money, which is also the definition of tender, which means to unconditionally offer money or performs to meet an obligation, which is essentially a promise. All right. And when we dive into the definition of negotiable instrument under UCC 1-304, or better yet, UCC 3-104, negotiable instrument means an unconditional promise or order to pay a fixed amount of money with or without interest and other charges described in the promise or order if it. So when you understand that our contracts are negotiable instruments, it requires specific foundations in order for it to be conscionable, okay? And if I'm butchering that word, it's all right. But courts can literally void any contract that is not conscionable, all right? So I want to talk about some of the common abuses in credit card agreements, okay? So here's some key examples. The first aspect of credit card abuses or common abuses of credit card agreements is the fact that interest rates hikes after you already agreed. So what happened is they'll give you a particular interest rate percentage, and then later down the line, your interest rate goes up, whether it's because of your credit, whether it's because they changed their policies, whatever the case may be. That right there is considered something that you didn't get to agree to from the very beginning. Okay, that's something that's probably written in the fine print. But then we also talk about the aspect of forced arbitration clauses, waiving your right to sue. So a lot of times when it comes to credit card agreements, you are forced to go to arbitration given the fact and you can't really use some of these debt collector practices unless it goes to a collection company. Okay. Then we talk about retroactive penalties and charges, late charges, and this, that, and the third. When you look at 15 USC 1666B, you dig what I'm saying? It says that timing of payments, a creditor may not treat a payment on a credit card account under an open-ended consumer credit plan as late for any purpose. Okay? And that's very interesting because, we get late fees, we get late payments, this, that, and the third, and that puts us in a position to where now we're in a disadvantageous position because now they use this against us, put us on our credit report. Our credit report reflects badly, and now we're unable to do things that we want to do with our credit. Okay. And then here's the other aspect of it not being no clear disclosures on how payments are applied. So this, when it comes to just the actual foundations of a contract, it must have disclosure, and a lot of times it doesn't. You dig what I'm saying? That right there makes any contract not meeting of the minds, any contract unconscionable, and essentially can be voided. All right. So remember, we're playing a contract game, not a debt game, not a discharge game. We're playing a contract game. So I'm going to talk a little bit about some lawful backing under 15 USC 1632, which essentially breaks down form disclosure. Long story short, this section breaks down the fact that any and every credit agreement should have clear and conspicuous disclosures. Okay, it says information in this subchapter shall be disclosed clearly and conspicuously in accordance with the regulation of the Bureau. What is clear? Clear is like literally you should be able to see it, and conspicuously means that it should be in the forefront. It shouldn't be something that you have to find out. Okay, and then we talk about the aspect of 15 USC 1637, which breaks down the obligations of credit issuers on open-ended consumer credit plans, which is a credit plan, which is a consumer credit transaction, which is a credit card. That, a credit card is an open-ended consumer credit plan. Okay, so they have obligations, okay, that they must follow, and they don't do that. It says, before opening any account, the creditor shall disclose to the person to whom the credit is extended each of the following items: the conditions under which a finance charge may be imposed, the method of determining the balance upon the finance charge, the method of determining the amount of the finance charge. Okay, where one or more periodic rates may be used to compute the finance charge, identification of other charges that may be imposed. In cases which the credit is or will be secured, a statement that a security interest has been or will be taken. Okay, a statement in a form prescribed by the regulation of the bureaus of the protection provided under 1666 and 1666I of this title to an obligor and the creditor's responsibilities under section 1666A and 1666I. Okay. Long story short, it's literally, I want you to truly think, like, have you ever gotten any of these type of disclosures? You may think you did, but if you're a person that did, then I want you to show me the disclosure. Okay. If you can't show me that disclosure right now, and this is essentially the same exact question I will ask a creditor, if you can't show that you have provided this information to me, then whatever credit card agreement that were essentially this open-ended consumer credit plan, this contract is null and void. Okay. And then we talk about the aspect of their duties under the Truth in Lending Act, which essentially breaks down the disclosure guidelines. They should disclose any and everything about the truth in lending, such as the source of funds, if they've actually used their own reserves, the guidelines of the disclosures, how you can be able to enforce things. And here's another thing that I like to talk about under 15 USC 1611 is the fact that they will be criminally liable for giving false or inaccurate information or fails to provide information which he is required to. So if you get in a position where they do not provide this information, that right there is a direct violation of the law. Okay? If they didn't hide the truth, you wouldn't sign the agreement, and they know it. Okay? If they just told you up front, hey, we're going to take your promissory note and we're going to make money on the front end of your promissory note, and then we're going to come after you for that money and charge you interest on the money that we have already received, you'll probably look at them like they were stupid. You're probably thinking and watching this video right now and saying, well, damn, if that's what happened, like, I'm actually pissed off now. See, if you're pissed off, that just shows that what we are agreeing to is not even something that's conscionable. Because why would we agree to something like that? Okay? Now, obviously, you can be strategic about it and you can play the game and be able to extract some benefit from it. But, you know, when you get into a position where it's like, man, all right, I really want to be outside of this system, then you start to be like, okay, I've been taken advantage of this entire time. And yes, we do take some level of accountability for not knowing this information. This is why it's important to understand that education, understand the laws behind it, because that is our responsibility. That is our duty. Because this stuff has been in the Constitution for, for years, and probably just now really looking at it. Okay? So here's why you were never truly gave informed consent. Now, what is informed consent? They informed you that, hey, look, you essentially have to consent to everything. And they informed you that they only inform you that your signature gives them consent to do whatever it is, such as waive your rights and things of that nature. But if they truly told you that you can consent to any and everything, okay, then you probably would maneuver much differently. But here's what we do wrong. Most people never read the full contract, okay? They never negotiate. So it's always the take it or leave it. They give you that incentive, but if I told you you have more negotiation power, you were the source, then they will have to maneuver a little bit differently, okay? Also, it does play a fact that most people kind of do it anyway, so they're like, hey, if this person's not going to do it, then all right, bet, then we'll just tell them we're good, okay? So this is why I come up with the content and talk about this on a consistent basis and make it open for anybody to learn, because I want more people to take action, okay? Number 3, the terms can change at any time without your approval. This is the thing. If you ask for them to negotiate and put in the contract that you require consent to any and everything that they decide to do, they probably wouldn't allow you to sign it. Okay? And then they use psychological manipulation. They make it seem like you are desperate for credit. And this is why I don't truly, especially at this point, I don't truly impressed to get into agreements and this, that, and the third. If I'm going to get something, I'll just pay cash or whatever the case may be. Sometimes I'll get credit, and obviously if you're starting something out, excellent. Okay, obviously if you're getting real estate or whatever the case may be, excellent. Okay, but there's other strategic ways that I won't talk about in this video to be able to get loans or whatever the case may be and have money or liquid so that you can be able to invest in yourself and your business. Okay, but where people kind of get messed up is the fact that they are truly desperate for credit. Okay, it's a law of attraction game. If you maneuver and you attract it, then it'll come to you. But if you chase it, then it'll run away. All right. So I want you to understand that that's not consent. That's actually coercion in a suit and tie. Okay. And that's the beauty about equity. So here's how you challenge the contract. Number 1, you send an affidavit of truth or a non-consent, which is what we talked about in my last video, non-negotiation affidavit, and essentially say, hey, look, man, I do not move forward unless there is informed consent. Also, at the same time, when you talk about an affidavit of truth, you are breaking down the facts that you know. If some of the facts that you know is that they securitize a loan, some of the facts that you know is that they made money off it. If you have truth and they are unable to rebut that truth, then it becomes true. It stands true in law. If they try to come after you for the debt, this is when you send them a debt validation letter according to 15 U.S.C. 1692G. You dig what I'm saying? You also can attach things like conditional acceptance for proof of lawful obligation, proof and challenge the direct epitome of the contract. Okay, can you prove that this contract was conscionable? Can you prove that you clearly and inconspicuously disclose any and all information in regards to this contract? As a matter of fact, can you just disclose that stuff right now and show me what you disclosed? Okay, you can demand the original wet ink contract with full disclosure and mutual consideration according to UCC Article 9 under the Truth in Lending Act, under the Fair Debt Collection Practices Act. And when you're asking for the original wet ink contract, they're going to give you a copy, but it'll have to be a certified copy, an authenticated copy. You dig what I'm saying? Meaning somebody bared witness to the copy of the original contract. Okay? If the contract wasn't lawful, then the debt has no foundation. If the contract is lawful and if you want me to pay my debt, especially if we are going back and forth and we're having a conversation, you dig what I'm saying? You know, and it does have foundation, it does have validity, then just provide it. Okay? Now, so number one, don't just pay out of fear. If you want to take control back, you want to not pay out of fear. If you pay out of convenience and, you know, you just trying to get the job done, not trying to worry about it, that makes sense, right? If you make enough money to where your bills are not overtaking your income, that makes sense, okay? But don't pay because you're scared, all right? That's where they have control. You want to use law, not emotion. When you're emotional and you get upset and you're more on a theoretical side and you're like, okay, well, damn, you know, they're taking advantage of me and this, that, and the third. You know, if you don't transmute that energy into learning the law, then you don't really deserve to get remedy, okay? Number three, keep everything in writing. I really want to emphasize this, and this is why I talk about the administrative process, because if you write to them and you ask them specific questions and they cannot provide that, you have evidence of them not moving in honor, okay? And you have evidence of you moving in good faith. You can call and make a phone call all you want, but it won't matter if you're going to get and not even get a legal recording that you can submit into discovery or something like that. Okay, so keep everything in writing and enforce that they give it back to you. Number four, know that the burden of proof is on them. When you start to ask them questions, it's not about you paying anymore. It's about them providing the proof, and then you will pay. If they want you to pay so bad, then just provide the proofs that you asked for. It's just that simple. And challenge not just the debt, but the contract itself. I think we get focused on the debt and discharging the debt, that we don't focus on the contract. I spoke to a client the other day that said, hey, look, I sent the letters, I did this, that, and the third, and you know, they didn't, nothing happened or it didn't work. And then I go and I say, okay, well, what's on your credit report? They say, well, it's just a bunch of charge-offs, but I still have my vehicle and this, that, and the third. I'm like, okay, it seems like it worked. The only thing that's truly affecting you is the fact that it has the charge-off on your credit report. But if that company is not coming after you for the vehicle, that company isn't asking for you to pay them anymore, if they charged off the debt, now you just have to communicate about the charge off. Just communicate about what they did. And according to the contract, according to the Truth in Lending Act, they should give you an informed use of your credit. And if they don't provide that, you use that against them. You know, I'm not really having a conversation and want them to reflect this. I don't care what numbers show up on their end, because they can put whatever. They can make it seem like I owe them $1 million, and there was no $1 million that they given to me to pay them back. You get what I'm saying? So I don't care if it doesn't reflect in their system. You dig what I'm saying? I only care about how it affects me externally and also internally. Okay? If it is affecting my credit report, I can fix that. Okay? But if they're not bothering me, they're not sending me any debt collection letters, you know, they're not, you know, trying to reach out to me, if they haven't taken my vehicle, then that's a win. But some people don't look at a win like that. So this is when you start to take those extra steps. This is when you decide to go and challenge the credit bureau. See, the credit bureaus, they're on a separate agreement, separate contract than those debt collectors. Even though by law, if you start to dispute a debt, they must remove it off the credit report or stop reporting. And that's something that you can use against them. Hey, look, they're still reporting negative information and unverified information on my credit report when I asked them not to. that is a direct violation of the contract itself, of the Truth in Lending Act, of the Fair Debt Collection Practices Act. Okay? So long story short, when it comes to the contract, you don't owe what you didn't lawfully agree to. If it's unconscionable and you didn't understand exactly what it is that you agreed to, you didn't have capacity to understand what it is that you agreed to, they say, well, why would you sign the agreement? It's psychological coercion, making me think that I have no choice but to sign it, making me think that it is non-negotiable, but the reality is it is negotiable. All right? So don't let these creditors take advantage of you, okay? And not just on the aspect of, getting emotional about it, but, learn the law. Learn what powers you actually have and assert them when you need to, okay? Whether it's a repossession, whether it's them attempting to collect on a debt, whether you're trying to get a charge off your credit report, you use these strategies so that you can build up a case and evidence to get those things off your credit report, to keep them from taking legal action that can affect you physically in a big way. You know what I mean? This is exactly why you learn this, not so you feel like you are stuck following their rules, okay? Because they have their own rules, but you create the rules, okay? You don't ask for permission. You dig me? That's the true way out of the matrix. And until you realize that the true way out the matrix is understanding the truth and using the truth to your benefit, instead of letting the truth make you emotional and there's a saying, once you know better, you do better, and then procrastinating on that. Oh, I do know better, but I'm just not going to do it. Sometimes we don't want the responsibility of the truth because we don't want to take action. You dig what I'm saying? We prefer to be, red pill, blue pill. We will take, I don't know which one it is, but we will take the blue pill and stay in our regular lives if we could. But once you learn the truth, it's hard for you to not exercise against it or exercise towards it. All right? So they write these contracts and knowing you'll never question them. But once you understand what makes a contract enforceable, you stop being a victim and you start being a creditor. See, being a creditor has nothing to do with you having to fill out all of these forms in the public eye. But if you know who you are and you can communicate it at that given moment, then you are putting yourself in a position where you stand exactly where you say you stand, okay? And they will have to prove otherwise, all right? So if you've gotten this far, thank you for watching this video. Down below, I'll put together an unconscionable contract challenge kit. So make sure you guys stay tuned for that. Grab the Complete That guide for that. You grab the Complete That guide, you become an affiliate, but also at the same time, tap in with my one-on-one mentorship if you're looking to fix your credit, get funding, or better yet, start your own credit repair business. You dig what I'm saying? If you're looking to do those things, perfect, tap in. If you have a business and you're looking to take it online, digitally, tap into that as well. Okay, it's a very strict application process. Depending on your answers will determine if you even get on the phone with me. All right, so be strategic about that and don't just book a call and not be ready. Number 2, okay, or number 3, 4, whatever. Follow me on Instagram at biz.nick. Follow me on Twitch at biz_nick. The free Discord is down below so that you can get an update every time I post a video. Tap into the Discord. You dig what I'm saying? Also, for all my streaming experts, I know that not everybody here is into streaming or whatever the case may be, but tap into the Twitch. Anybody who's a streaming expert, tap in with me, lock in with me. I could definitely use your help. You dig what I'm saying? Join the Discord, give suggestions and ideas, send videos in the Discord. I'll react to videos on stream. Tap in with the stream. You get what I'm saying? And lastly, if you've gotten this far, remember to like, subscribe, turn on the post notifications, and comment the word discharge if you got all the way to the end, because you're a real one. Thank you guys. I love you, and I'll see you in the next one. Gone.